Hello friends, in the series on the income tax cases, today we will discuss the case of ACHAL Kumar AGRAWAL versus Principal Commissioner of Income Tax and another. This case has been reported in 455 ITR at page number 380. The matter has been decided by Allahabad High Court in a writ petition filed by the Assessee, and the date of the judgment is 9th January 2023. This case is a little bit technical, but it is very important to discuss this case because it gives a understanding that it is very important for an assessee to raise as a ground the findings of the assessing authority in the assessment order. If the assessee do not raise those grounds or do not challenge those findings at the lower appellate authorities, then it will be very difficult for the assessee to raise those grounds or to object those findings at a later stage. In this case, the assessment order under section 147 was passed and some additions were made. In that assessment order, the assessing authority has mentioned in the assessment order that the notice under section 148 has been served on the assessee, and there was categorically finding in the assessment order that this notice has been served on to the assessee. The assessee chooses to challenge this assessment order under section 264 at the Commissioner of Income Tax level. The assessee has not gone into the CIT appeal, but the assessee has chosen to opt section 264 revision petition. In that revision petition, the assessee has not challenged this finding of the assessing officer that the notice under section 148 has been served on the assessee. The Commissioner of Income Tax dismissed the revision petition of the assessee on merits. When this revision petition was dismissed, because as all we know that when the assessee chooses the path of 264 revision, then the assessee loses its right to challenge this order at the higher level like IT-80. So the assessee went to the writ court to challenge this order on the ground that the notice under section 148 has not been issued to the assessee and the assessment has been done. When the Allahabad High Court heard this petition, Allahabad High Court was of the opinion that the assessee has not challenged the findings of the assessing officer, that the notice has been served on the assessee and there was categorically findings regarding that the assessee has been served the notice under section 148. So the assessee cannot come to the writ court by taking the plea first time, which the assessee has not taken at the lower level, neither at 264 level or any appellate authority, and directly come to the High Court for the first time that the assessee has not been issued the notice under section 148. So the crux of the matter is that if the assessee has not taken the ground or has not challenged the findings of the assessing authority at the lower levels, then the assessee loses its right at the writ court to challenge those findings for the first time, because the role of the writ court is very limited and the writ courts are very slow for giving the decisions on the facts and on the administrative matters. Friends, this case is very important because whenever we make our grounds of appeal, then we should be very clear that what grounds we are taking, because if we take the grounds and later on we feel that we have left some grounds, then in case the grounds are of legal nature, purely legal nature, for which the facts are already on record, those facts can be easily admitted. But for those grounds for which the facts are not on record, those grounds are very difficult to take at the higher forums. At the end of this video, once again I am Repeating the name of the case is ACHAL Kumar AGRAWAL versus Principal Commissioner of Income Tax, and this case has been reported at 455 ITR at page number 380. The matter has been decided by Allahabad High Court and the date of the judgment is 9th January 2023. Thank you, friends.